All right, this is Rashida Morris here with Carrie Ann Cook and Natasha. We're getting ready to Natasha Townsend. We're getting ready to show our presentation for our research that we found. I'm going to first bring up, I'm all over the place, just our fact pattern that we're working on, which is Joe is an airline pilot. He's making a claim for intentional infliction of emotional distress against Jane. In discovery, Jane requests any required medical disclosures to the Federal Aviation Administration regarding Joe's mental health. Joe objects, and the question is Jane entitled to the information? So I'm going to go ahead and start my presentation first. Hi, this is Rashida Morris of the group, the Gambini Firm, doing presentation 2. Just our fact pattern here, we have the Rules of Civil Procedure, Rule 34. We have the option of doing both Tennessee or Alabama. So we've starting off with Tennessee. Just our fact pattern here that Joe's an airline pilot. He made a claim for intentional infliction of emotional distress against Jane. In discovery, she requested any required medical disclosures to support Joe's claim for mental health. Joe objects to it. And the question is whether Jane is entitled to the information. So pretty much cut and dry. These are just some notes that I pulled. I tend to just copy and paste notes that I find on the information, so just quite a few here. My go-to is TennesseeCourts.gov. Which is where I go to find a lot of the rules and jurisdictions and things like that. This is just the rule projection of documents and things and entry upon land for inspection and other purposes. Just a brief definition of what is discovery privileged information. Privileged information is information that is protected by a confidential relationship recognized by law, such as attorney-client, in our case, doctor-patient, etc. So this pretty much is what we're looking for. In Rule 3403, I found that the provision of this rule permits a party to obtain documents which are subject to another party's effective control, e.g. medical records. Pretty much what that is indicating is that that person pretty much has to give consent. So whether it be written consent or otherwise, the person controls the narrative on that. So let me just go ahead and go to the rule so you can see the actual page. So here we are, Rule 34. This is again, TennesseeCourts.gov is where I want you to find information. And here we are. Persons, not parties. So just a specific person and that's requesting it, not so many parts. I guess what that's pretty much is indicating that the person that's requiring is the only person that can have access to that, given consent that they have access. I just a few things that's part of my notes as well. Just some scopes and limits to that rule 2602 as part of my notes. Let me go there, where it shows that a party may not discover the identity of facts known by or opinions held by experts who has been consulted by another party in anticipation of. So with that, let me go ahead and go back here, 2602. And let's see here, quite a few reading there. Okay, so yeah, so pretty much if they're requesting the information, has to be for a good cause. So it can be requested in bad faith, I'll say that. I found some cases, I'm gonna go ahead and go back to Westlaw. just a moment, but I wanted to show you in Justtia law, which is another good place to look. 2010 Tennessee Code Title 63 professions of the healing arts when it comes to medical records and release of medical records. Pretty much the people that can obtain that, because there is an exception to getting those records. So like schools, childcare providers, things like that. Other licensed healthcare providers like psychologists, psychiatrists, obtaining those medical records will not be an issue. So those are pretty much the exceptions, and that's just pretty much what this Title 63 is saying. Let me also pull something else here for Justia law. Let's see. Maybe we search medical records. I think that's in Title 24 in Tennessee. Let's see, Title 24. Because what we're looking for is like witnesses and evidence, things like that. Let's see, medical records. As you can see, I'm doing the search. It's not always easy. You don't always get exactly what you're looking for. Sometimes you have to go a little extra step. Let's see, Tennessee law. Tennessee code. Let's see, 2000. Case law. Let's just try Tennessee. Evidence and witnesses. Depositions. Lost evidence. Proof of public acts and records. Let's try that. No, let's go back a bit. Admissibility of evidence. Let's try chapter 7. That might be what we're looking for. And yeah, see, this says medical records 24-7-122. So this might be it. And I'm sorry about that. Okay, so here we go. 24-7-122B. Medical records or reproduction of medical records when duly certified by their custodian, physician, physical therapist, or chiropractor need to be identified at the trial and may be used in any manner in which records identified at the trial by these persons could be used. These records shall be accompanied by a statement signed by the person containing the following information. The person has authority to certify the records. The copy of the records is true and all the records described in the subpoena. The records were prepared by the personnel of the company acting under the control, here we go, of the company in the ordinary course of business. Yeah, so, and this just gives a timer. They usually have 60 days before the trial to actually produce those documents. But this is what we're looking for when it talked about the scope of limits here. So that's what Rule 26.2 in the Tennessee rules. And here we go. That also ties that together with Rule 34.03 as far as documents are subject to parties' effective control. So yeah, so that gives us what we're looking for. Part of my other notes, I wanted to go here to find a law, because this is where it talks about The privacy of one's medical records is protected by both federal and state law, and is generally considered information confidential under Tennessee law. It shows hospital records are considered property of the hospital and are only accessible by court order or a written request by the patient. Um, so when it comes to a court order, that's where the exception lies. It's not really a blurred line, but it's more so where it has to be disclosed, like if a person is sick with HIV AIDS or any sort of that will affect the public as a whole. If they got COVID, no COVID-19, so that's a good example. So that type of information must be disclosed no matter what. So that's the exception to that rule. But in our fact pattern, however, in James' case, as far as entitlement, the answer to that question would be no, because it's not a dire need that would warrant those exceptions for something like that. So, unfortunately, she's out of gas on that, but that is what this shows and what this proves. So, yeah, so mandatory reporting requirements for communicable diseases and sexually transmitted infections. So, that's what I just said. So, yeah, so that's something. That would be those exceptions. So a written request by the patient as well, or so if Joe consents to it, then yes, she can have it. If he does not, unfortunately, she's out of gas. So that proves that point. I wanted to go to Westlaw. Let's see here. Just going to open up a new tab. We're going to go to Westlaw. Okay. And these are just some cases that I found. These are a couple of cases that my classmate found, which we'll touch on that in just a moment. But just based on the search, just plain language law, so medical records in Tennessee. And the only reason why I found these cases is because it's stating the information that we actually read. So Martin v. Rolling Hills Hospital LLC. Let's see here. Let's see, maybe a different one. Okay, here we go. We have Stevens v. Hickman, County Health Community Services. So I just actually pulled it just for this statement because HIPAA itself prohibits medical providers from using or disclosing a plaintiff's medical records without a fully compliant authorization form. It is a threshold requirement of the statute that the plaintiff's medical authorization must be sufficient to enable defendants to obtain and review a plaintiff's relevant medical records. So that's really why I pulled these cases, just for that, that particular statement, so that supports what we found in Justia Law and the other notes that we also found as well. As far as when it comes to public information, this is just here a request for public records and the discovery procedures with that. This is a background just for Rule 26 of the Tennessee Rules of Civil Procedure, where a party to litigation is permitted to obtain information such as depositions, questionnaires, documents, books, and other relevant materials in the possession of an opposing party, which is just a definition where it says commonly referred to as discovery. So when it comes to certain public information, maybe the address may be public, or the person's name. So if I type my name in Google, you'll probably find a lot of people under my name, and it may list that address. Matter of fact, let's try it. So let's see if we go to Google, and let's just, okay. several variation of my name. So as you can see, you can find me on Facebook, YouTube. There's one that's acting, and there's one that's a musician. I'm a musician, but this is not me. But and my Twitter handle, I haven't used that in a long time. So yeah, so just said, here we go, warrants, arrest, mugshots. We don't want to look at that. We found Morris, view public records online. So usually in these things you have to pay for, pay the company. So that's one thing that it also mentioned, is at the expense of the person that's in control. So yeah, so that just pretty much answers that question. And then we have the Tennessee Code Public Records Act, that's 10-7-501. Any citizen is entitled upon request to inspect public records of state and local government entities. Although the law does provide some exceptions, most of these records of the state and local government entities are required to be made available for public inspection. Um, and this just talks about problems with it because there is a bit of an inconsistency with that. But I think once you understand exactly what you need and what you're looking for, it becomes a lot easier. I pulled, this is part of my notes as well, Lorman, medical records law in Tennessee, release of records slash confidentiality of patient records of physicians, clinics, and hospitals. I chose this one because there was a case of Givens v. Mullikins, which is a Tennessee case, a recent Tennessee case from 2002, where the plaintiff actually sued the defendant, the physician, for alleging he had a duty to keep private and privileged information he obtained by virtue of his contract of employment as the plaintiff's physician, and that the defendant doctor breached his duty by forwarding a copy of the report as alleged. The issue before the court was whether the communication between physician and patients are by law privileged communications, which yes, they are, and whether a disclosure of such information to a third party gives rise to a cause of action under the law. And actually, yes, because if he did not give written consent, or if it didn't fall under the scope of those exceptions, then he would be correct. So yeah, so I just wanted to show that. Now, my classmates will be following up with the actual cases, excuse me, that they found, as well, to support our research. And as an added bonus, we also took the liberty of um, locating the statutes and everything for Alabama. What I wanted to do is give you some of the links that we found under Miss Carrie Ann. So I want to show you that. Okay, oh, and she's already uploaded to YouTube. So we're all, okay, here we go. So we're all pretty much the cases and things that she found for Alabama. So she's going to go over that with you, and you'll be able to get more information with that. Um, so this one will be good. And again, thank you.
All right, so we're going to now continue on to the close out of mine. And we're going to make sure I close out of the right window. If I can get it. Okay, yeah, here we go. And now let's go ahead and go to part 2, which we're going to start with Natasha. Make sure you all can see that. And there we go.
So going off of Rashida's initial research, the first thing I do is I go to the rules of civil procedure so I can read in full what Rule 34 says about the scope of discovery. I click on scope, and I'm reading what it says about what type of discovery is allowed, but I don't see anything about medical records in particular, but I do see that it has to be within the scope of Rule 2402. So I go back up and then I go and look for Rule 2402, excuse me, 2602. And right here it says parties may obtain discovery regarding any matter not privileged. So that's very important. So from there, I log into Westlaw. I search for emotional distress and medical records. And I come up with all these results. So I scroll through and I come across this case, this Flex v. Daimler Chrysler Corp. And it says negligent infliction of emotional distress has to be supported with expert medical or scientific proof. So as I'm reading, I'm seeing that in the holdings, the Supreme Court held that the mother is required to support her negligent infliction of emotional distress claim with expert medical or scientific proof. So I go back to my search bar and I type in negligent infliction of emotional distress. So with this, you have 5 elements, the last one being support his or her serious severe injury with expert medical or scientific proof. So now I want to go back and see what the elements are. Intentional infliction of emotional distress. And here, there's 3 elements, but there's no requirement for expert medical or scientific proof. So I go back and I look up intentional infliction of emotional distress again, and I click on this case that is highlighted up under the elements of the tort. This case is Rogers v. Louisville Land Company. And right here it says the mother failed to prove that there was a serious mental injury as an element of her claim of intentional infliction of emotional distress. So I scroll down. I like reading the head notes because they help give you an idea of what was in the actual application in the case. So again, here we have when the cause of action for negligent infliction. So it does require expert proof. So here it says that both negligent and intentional require proof of serious severe mental injury. So I click on the cases on that. And the first one here is Pagliara v. Moses. I want to click on that. So here I can see that a husband's trying to allege both negligent and intentional infliction, emotional distress from his wife. And right here, the elements of intentional infliction. And if we scroll down some more, here we are, the elements of negligent infliction. Now, the differences between the 2 torts is that one has an element of negligence. Okay, so what I want to do is I want to go back and I want to do a search on medical records and emotional distress to see what's required there. So I scroll through these cases and I come upon Nyron v. Holland. So I click on here and I scroll through and I'm not really seeing much of what I'm looking for. But then I see a reference to this case, necessary to establish mental injury element, Miller v. Wilbanks. So when I click on the citation, it takes me right to the paragraph that is referencing. And right here within the first statement, it says that intentional infliction of emotional distress does not require expert testimony. So I'm going to save this to my folder for later reference. I'm going to add a new folder. title it Presentation 2, and save this case to my. Oh, I think it cut off. Essentially, what I found with that last case was that because the two types of torts, the intentional infliction of emotional distress and the negligent infliction, had similar elements, but the negligence had the added element of the negligence, which required that medical or scientific proof be provided, whereas the intentional did not require that. The fact of proof that what they required for proving the severe injury, it didn't. One of the cases said that it didn't require that, like you could use medical proof, but it wasn't required. So that was my findings with that.
All right. Well, now we're going to go ahead and start the last part of our presentation, which is going to be Carrie Ann. And she's already uploaded to YouTube. So I'm just going to go ahead and hit start. And here we go.
Our topic, we were assigned the jurisdictions of either Tennessee or Alabama. Natasha covered the rules and statutes for our question under the jurisdiction of Tennessee. So now I'm going to be looking for the rules in Alabama just so that we can compare and see if the two states line up, or if they do have any differences on this issue. So of course, just to start off, signing into Westlaw, changing the jurisdiction to include only Alabama. And then the first thing that I want to look for is the elements of intentional infliction of emotional distress. So I'm starting out with just a really basic search for that here, just intentional infliction, emotional distress. So I want to find something that clearly lists out the elements for this in Alabama. And the third search result right here looks promising. That little part at the end, it looks like it might list them out here. So let's look at Harrelson v. RJ. Just skimming through, looking for the elements. Let's see. And here it is right here. So it says this court in 1980 recognized the tort of intentional infliction of emotional distress and defined the parameters for such an action. So there are 4 elements that must be met for intentional infliction of emotional distress in Alabama. And I'm going to put this back in and look up what the elements are specifically right here. Okay, so here they are right here. And the 4 elements are intention, extreme and outrageous conduct, the defendant caused the plaintiff distress, and the distress was severe. Okay, so now to compare, I'm looking for the elements of negligent infliction of emotional distress in Alabama. And through this. First case right here.
Excuse me.
So after reading through this a little bit, I found out that Alabama does not recognize negligent infliction of emotional distress. So there's nothing to compare it to like we did for Tennessee. They recognize negligence on its own, but negligent infliction of emotional distress, it is not recognized in Alabama at all. So I'm just scrolling through a little bit more right here. We note that this court has previously refused to recognize negligent infliction of emotional distress as actionable. So now to get a little more specific for our topic, I'm looking at mental health, emotional distress. And I'm going to look at this first case right here that comes up. This has to do with a mental health center. And it was in Alabama and our Supreme Court of Alabama in 2003. Neither employee nor individual waived psychotherapist patient privilege. So the issue is whether the psychotherapist patient privilege, and there's the statute for that, bars discovery of certain mental health records. So that's exactly what we're looking for here. And right here it says that there are only 5 very specific exceptions to that privilege. And it's the first one is child custody. Insanity is one of them. Or of course, if that privilege is waived, which for our topic, it was not. And this was the holding here. We hold that by merely alleging mental anguish and emotional distress, the plaintiffs in these cases have not waived psychotherapist patient privilege conferred by that statute. Because the privilege applies in these cases and has not been waived, Western is not required to produce the subpoenaed documents. So that is basically the answer to what we need to know under the jurisdiction of Alabama. But I'm scrolling to the bottom. And so again, it says, we hold that the records the trial courts ordered Western to produce are privileged and confidential and are not subject to production under the facts of these cases. Therefore, the petitions are granted and the trial courts are directed to vacate their orders compelling discovery. So to wrap all of this up in terms of the specific topic that we were assigned, no, she is not entitled to Joe's mental health records in Alabama either.
All right, so that concludes our presentation. And anything else, y'all have anything else to say? Any closing remarks?
No.
Nope. Carrie Ann?
Nope, I think that's it.
All right, well, that's going to conclude. I'm going to go ahead and stop the recording.